The town did it. The lawyer for the gas drilling company said, I'm going to sue you. He spent 3 weeks on the radio going across saying, I'm going to sue you for takings. Long story short, he didn't. He sued the town for authority, but not for takings. Middlefield was basically a similar situation, no taking suit. They both got sued in the summer. So those were 2 of the first 4 towns that passed protective laws. Since then, there have been over 100 towns that have passed or are in the process, okay? In all but 10 of those other 90 or 100 towns, people have said if you pass a law like this, you're going to get sued. But they haven't been sued. The only people that got sued were 2 out of the first 4. There have been 80 or 90 or 100, however you want to count them, since then. In virtually every case, people said you're going to get sued if you pass one, but they didn't get sued. All right, so people used to say, this was last summer, used to say, well, don't pass a law like this, a moratorium, until the judges rule in Dryden and Middlefield. Well, the judges have ruled in Dryden and Middlefield. The first one that came down was February 21st, the first line in Dryden. The first line of that, the decision is, this is a case of first impression. I mention that because, as I said, there were no cases at all on this issue. There are people who will tell you there was one case, but it's not on this issue. So the judge agrees for what that's worth. That's why they opened with, this is a case of first impression. What they found, what the judge found there is that the ECL 2303-032, the gas plant station, does not preempt a municipality's authority to ban operations related to oil and gas production. So whether it's a moratorium or otherwise. All right, 3 days later, the decision came down in Middlefield. Exactly the same thing. You're not preempting. Okay? The way they put it, which is pretty elegant actually, the way that judge put it, bless you, is that municipalities maintain control over the where. So a town can say yes or no, not here. But the state, the DEC, maintains control over the how. So let's say that the setbacks, for example, for schools and houses are 100 to 150 feet. Let's say that you didn't like that in your town. You thought, you know what, I'm okay with this, but I want 1,000-foot setbacks or 2,000-foot setbacks. You can't do that. You don't have the authority to do that. That's the how. Setbacks are the how. So all you can say is yea or nay. That extends to a moratorium as well as any other kind of law. But if you don't say nay, then the state does the how. Okay? So the people who had said wait until the judges rule, now, because the way the judges rule, now say, well, don't wait till, I can't make that go backwards. But they now say wait until the appellate court rules. Well, experienced lawyers agree that it will take at least 2 years before these cases get to the appellate court. And there's no question that in that period of time, the DEC will have begun issuing drilling permits. So if you decide to wait to not pass a law like this until you go all the way up through the appellate decision, by definition, you're going to wait to a time beyond which, or past the time that the DEC has been issuing permits. If you do that, that does 2 things that we think are not good for towns. First of all, it deprives the town of the ability to use the only protections of local control that the DEC has built into the draft ESCARs. And that's the right to check that little box that says a proposal to frack is inconsistent with local land use laws. More importantly, we think that waiting is not the financially prudent thing to do. We believe that waiting to pass a protective law until after permits issued actually exposes the town's taxpayers to hundreds of thousands or even millions of dollars of potential liability. I know that's a big range, but it varies based on the property values in the town. That does not exist, or at least is dramatically lessened, if a town passes its law before the DEC begins issuing permits. This is another key slide, and this is another one that nobody has ever popped up and said, that's not true, and here's why. Okay? So, basically, it's because bringing a successful regulatory suit requires that the claimant prove she had a reasonable investment-backed expectation and they cannot prove that. We don't think they can prove it at all, but they certainly can't prove it if a particular law, a moratorium is enacted before the DEC issues permits. You can still pass a law like this after permits issued, but if you do it after, the horse is out of the barn, and then we get into that grandfathering concept we were talking about. It's really important to understand. All right, I don't think we need that. Keep in mind that in those two suits, and again, both Dryden and Newfield won those suits at the trial court level. They won them unequivocally. Sometimes you get a legal decision, and you can see the judge struggling, kind of like a Berkeley on the one hand, on the other. There's none of that in these cases. Unequivocal decisions. But keep in mind that neither one of those suits alleges a penny's worth of damages against the town, financial damages. Not for takings or any other cause of action. When you're a lawyer and you defend somebody, you have to play the cards that are dealt you if you're defending someone. So if I'm defending the supervisor and he was found with a pound of cocaine in his trunk or something, those are the cards that I'm dealt, the fact that there was cocaine in his trunk. When you bring a lawsuit, which is called being a plaintiff, you get to pick the cards that you're going to play. And you can even pick jokers, okay? So in this case, and this guy who represented the gas company in Dryden is a very, very good lawyer. So none of what I'm going to tell you can be chalked up to like a rookie mistake or something. This guy's a good lawyer. The cards he played, in other words, his own papers that he filed, said that his client's company spent $4.7 million on leases. But he didn't. He put that in his papers. But he didn't try to get that $4.7 million back. He didn't try to get anything back. Not for the taking or otherwise. Nor did the plaintiff in Middlefield. Okay? Neither one of those put anything financial, put the town at risk for financial damages. All they were at risk for was the lawyer's fees. We can talk about that later. All right, so this I'm going to go by. I think that's it, is what I'm going to do with this. I just want to end with where I started before we get to the question part. And that is really, really, really important point. Consideration by this or any other board as to whether a moratorium should be enacted or a decision to enact a moratorium in any form does not mean that the board members considering or voting to enact that moratorium have made up their minds about whether gas drilling is an appropriate use for that town or whether fracking has been proven safe. The only thing it means is that those town board members believe it's in the best interest of the town as a whole, all of the residents of the town as a whole, to study more and gather more information during whatever the moratorium period is to help them make an informed decision. That's it.